let us go to the topic, dear friends. So, as all we know that Family Courts Act has been in force from 1984 onwards. It has commenced and it has been notified to be in practice from 12 to um, sorry, it is we called as Act 66 of 84. And later there was an amendment also to this act, which has again come into force on 12 to 2015. I think I mentioned it wrongly here. I marked it wrongly. Anyway, we'll go for the objects. See, the objects of the act is to provide for an establishment of the family court. It is because of the struggles and demands of continuous demands of the women organizations and associations all over India to make the matrimonial laws and the dispute resolution more comfortable and easier when they are dealing with the matters of relating to family. So the Family Courts Act basically had three major objects. One is that, first and foremost, is that it is to promote the conciliation. So for every act, we can see from 1947 or 1950 onwards, which is in tune with Constitution of India, or which is well within the ambit of Constitution of India. This is the one act which is very specific, and the objective also, and the entire setting up of the act, and the idea of bringing this act itself is to bring about conciliation. Most of the times when there are problems between two parties or two groups of people, or the problem between the government agency and the citizen, when there will be a redressal kind of a act that has been in force and in vogue, this is the first act which can say that the conciliation is the first main object of this act. The second objective is that it has to secure speedy settlement of disputes. See, whether it is disputes are always conciliated to be an amicable settlement for the couple to reunite or not. The second object is to secure speedy settlement of disputes. The third one is the disputes relating to all marriage, family affairs, and matters concerning therewith. That means when the marriage is there, the children will come. When children are there and the family is there, the maintenance used to come. And when children are there, whose the guardianship of the children has to be decided, it has to be with which parent, and the custody and the visitation. See, each and every aspect that relates to the family or the properties that has been purchased by the couple, or when they're parting, how it has to be separated between them, and all these aspects come within the family. So it says it is not only the matters relating to marriage, it is matters relating to marriage and the family affairs, and matters concerned therewith. So it is it encompassing several aspects of matrimonial causes. So when people used to ask whether you're a person follow what kind of practice you have, many people will say they are dealing with divorces. So this is the common idea of normal ordinary people who are not aware of the legal field or the courts and other things. But normally, as we lawyers, we need to say, to be more appropriate and more precise, that the matters relating to matrimonial causes. Matrimonial causes is the special as genre of law, which has come into force for the past 35 years nearly. And it is quite new. Even though the act is in 84, there were one court or there were two courts in the entire state. And slowly it has taken very good shape, and the courts, several courts have been formed and established. And as the act is also providing for, that is in objectives and whatever they want to, the manner in which they want to establish these courts, it says that there should be a court, there shall be a court established, a family court be established wherever there is 1 million of population, that is 10 lakhs. Whichever town, whichever city, whichever place, it has a population of more than 10 lakhs, then there has to be a family court that has to be set up. This is the idea of a act, which is very most important act in our country, because though there are political issues, economic and other issues, the family is the basic unit of our whole society. So that basic unit or the basic smallest structure of the society is family. So when there are problems in the family, and that is completely new when it is considered to what it was before 40 years, what it was before 50 years, or what it was before 73 years, or at the time of independence. So every 5 years, we can say that there is a big generation gap is coming. So the generation is actually understood to be something like 13 or 14 years. But we are able to see the generation gap is now very clearly seen or established within 5 years or within 7 years. So fast the society and the economy and the technology and the innovations and scientific new products and other things are coming up. So the mindset and the relationship, interpersonal relationship, and the marriage as a institution, and the family built under the marriage institution, all these things are going for a very big change. And every time, whenever there is a problem, or whenever there is a problem to that is capable of being resolved, but there are no structure that is available in the society to solve those smaller problem or bigger problem. See, those days before 35-40 years, we were able to see there were lots of joint families. So if there is a problem for a young couple, there will be a middle-aged couple, there will be a old couple, and the senior most couple in the same family, where about 2 or 3 generations of people will live in the same house, which is called joint family. So now we have to show our children what is joint family, what is nuclear family. Even it has to be shown in the pictures. That is the reality. So when the children are going to school, when there is grandfather, grandparents are living, a small child is telling me, when your family photo is there, why the grandmother, grandfather is not there? The child tells me that it is an extended family, this is not the family. So auntie, the extended family means only the grandparents will come. So even the families are not willing to accept their own father and mother when they are old and when they are living also. The concepts are changing, but still the human values are the same, and we need to perpetuate the good values and the love and affection and trust within the members, and all these things are very essential. So this act is most essential in terms of this society thriving in good values and continue to produce very good human beings for the future of India also. So in that aspect, let us just go into this act and this lecture. So there are very reasonable efforts for a settlement before trial has to be taken, is the one of the main aspect of this act. So the emphasis is laid on conciliation and socially desirable results is one of the objects that has been expressed even at the time of setting out the law, and even when it was printed in the Gazette also. So two aspects. So emphasis on conciliation. So when people used to say the matter has gone to the court, everyone will know that it is not resolvable. The final stage of a problem only will go to the court. So there is no resolution possible, then they go to the court. So this is the very idea of courts and the legal system. When the problem is unsolvable, it is not possible to settle it amicably, only then the matter goes to the court. And how long it will take, nobody knows. So this is the common man's idea about law and court and justice. So when people think that this will take very long time, by the time the couple will lose their very prime time of their life and youth, or the children when they are 3 or 4 years or 5 years old, when the parents come to the court, the children will be 17 or 18, and they would have really lost their complete childhood by the not parents not living together. So these are all the things what prompted the lawmakers to make this law a special one, to see to that the speedy resolution, speedy settlement of the disputes are taken up. So when CPC was amended in 1976, it also provided for a special procedure that is to be adopted in the suit that was relating to the family disputes. So even before 1984, there were ideas and there were a requirement that matrimonial matters, the suits relating to the matrimonial matters, should be seen in a different manner, and it has to have some special procedures so that the delay will be avoided. That was the idea in 1976 itself. So when the 1984, the courts were set up, it was very clear. In 1991, when it was amended, it very clearly, very properly, in a very appropriate manner, it added 125 CRPC, which is the jurisdiction of a judicial magistrate court, has to be dealt by family courts also. So that 125 CRPC, which is falling under the specific domain of the lowest accessible court for the public, has also been made available to be dealt by, to be handled by the family court. And because, as we saw earlier, all matters relating to the family affairs should be dealt in one-stop shop kind of a court. So the people or a women or the children or old parents whom are in request or in the requirement of taking a maintenance from their son or husband or father, they need not be pushed to some other court while the parents or the couple are fighting in the family court. So that is the reason why in 1991, in the Amending Act 59 of 1991, it has been made available, even 125 CRPC comes under the ambit of Family Courts Act. And the Family Courts Act, very specially in section 13, 14 and 15, they formulated a special procedure. See, when all other acts speak about the jurisdiction, the entitlements and the sanctions when it is not followed or it is violated, the family courts itself is a special act which is very comprehensive, so that it had a special procedure within itself. Though it's a small act of about a very short number of provisions, it also says that 3 provisions are specially given for the special procedure. As we all know, that it is section 14 very clearly says it has to be, there can be an evidence that can be taken from the family courts, by family courts, even though it is not strictly admissible as per Indian Evidence Act. So we will come to that later. So when section 4.4 as a major objective, that is behind enactment, it has to have a specialized body to preserve and save the interest of marriage. Then the constitutionality of this act has been questioned. But the Supreme Court in Kasturi versus Kasturi, it has very clearly held that the special procedure, which is not applicable for any other suits, will definitely be applicable for matrimonial matters, and that has been upheld. So that is 2018 5 SCC 353. You can go through that judgment to say how this is special provision is absolutely valid, and that is very essential for this special court. And what are all the matters that can be taken up by family courts is very clearly stated in section 7.1 of the Act. So section 7.1, there was a doubt again whether family court is a tribunal or not, or it is a court itself. Since it is strict sense, it is not adjudicating the disputes alone. When it is not adjudicating the disputes in the manner known to law for all these years till 1984, then the question was whether it also provided or also done some of the acts of court. Then in S.D. Joshi versus High Court of Bombay in 2011, 1 SEC 252, it has very clearly stated that family court is not a tribunal, but an act and a court. As an act, it has all trappings of a court, and thus it is a court. Since section 13, 14, 15, and certain other sections of section 9, and taking the welfare experts' opinion, and admissibility of evidence which is not strictly admissible as per Evidence Act, all these special provisions has made, given raised one case in S.D. Joshi. So friends can go through this judgment and understand how the Supreme Court has very clearly held that it has got all trappings of the court, and hence family court is in all senses, it is a court also. So we would not have thought whether anybody could have disputed or adjudicated on these matters, but Supreme Court has, and we need to go through when we want to understand this act in a very comprehensive manner, and to see how special it is and how very unique it is. So in when it is asked for a speedy settlement of disputes. After 1984, after 90s and 2000s, when family court has come into play in all states and several cities and several small towns also, then the speedy settlement of disputes were not happening. And when it was essential that has to happen, or when it was questioned that it was hastily done and all that, Supreme Court once again came forward to speak about the speedy settlement of dispute is an essential integral part of this act in Shantini versus Vijay Venkatesh, 2018, 1 SEC 1. The Shantini versus Vijay Venkatesh case has been widely followed even in day-to-day affairs by the judges of family court, because it has given several special provision for the judges and the court of highest family courts to deal with the matter in a very specialized manner, because the court is governed by the Family Courts Act. It is not in strict sense like any other civil courts, like any other district court, like any other appellate court or from the lower level. It is a very special court which has to deal with the matter in a very special manner, so as to reach out the objectives of this act. So for us to understand the concept of speedy settlement of disputes, one should go through again Shantini versus Vijay Venkatesh, 2018, 1 SEC 1. So when we can see what are all the aspects or the petitions that can be filed before the family court under section 7(1) of the act. So we all understand the first aspect, that is suit or proceeding for decree of nullity or annulment of marriage, or restitution of conjugal rights, or for judicial separation, or for divorce. We all know these 5 aspects are there to decide about a marriage. And secondly, the declaration as to the validity of marriage. There are several cases when we file as a suit to challenge a validity of marriage when it has been done without the legal requirements of the special of the personal law. When section 5 and 11 of the Hindu Marriage Act is not followed, or if it is violated, then the validity of the marriage itself will be in question. So one party may consider a particular marriage as a marriage, but the other party can always challenge it. So these kind of, whether it is a marriage or not, is a question. So when people understand this is the court for judicial separation, restitution of conjugal rights, divorce or nullity or annulment. Only if it is a marriage, then only per se the suits or proceedings can go from there. But when it comes to the validity of very marriage itself, whether it can come to family court. So section 1 clause 2 very clearly says that declaration as to validity of marriage itself is the subject matter of family court under 7(1). And any order and properties of the parties of marriage will definitely come under family courts. And order or injunction in circumstances arising out of marital relationship. When there is a marriage already, or another marriage is being done, the validity of first marriage, or the injunction to be granted for any alleged proceedings of marriage, which one party is already claims that she is married and all that, then such injunctions and any orders requiring any marital relationship also comes here. Then declaration as to the legitimacy of a person, definitely about a child, legitimacy of paternity of a child, all these aspects will be covered under this act. And for maintenance, any suit or proceedings for maintenance. We all know suit can also be filed, and the petition not only under the personal laws but also under 125 CRPC, as we saw earlier, it comes under the 7(1) of Family Courts Act. And then a suit or proceeding in relation to the guardianship of a person, or custody, or access to any minor. So there are 3 aspects now, as the section says. Guardianship is an aspect, and custody is yet another one, and access to the minor, which we all commonly know as or call as visitation rights to the minor child. So these are all the aspects that is being covered under 7(1), from 7(1)A to 7(1)G of the section very clearly says. So subject to the other provisions of the Act, 7.2 says the jurisdiction exercisable by the magistrate of first class under Chapter 9. Under Chapter 9 is, as I told you, it is Section 125 CRPC, that is for maintenance. And it is a summary proceedings. When the family courts are the courts of a district court's cadre or in the same level of district court, it is also having the jurisdiction and the authority to deal with a specific matter as to what is dealt by judicial magistrate court or a metropolitan magistrate courts, as the case may be. So this is for the convenience or for the comprehensiveness of the matrimonial matters and affairs. If imagine the 125 CRPC is not under the Family Courts Act, there cannot be any case, even if the petitioner or the respondent wants to file a case under 125 CRPC. If the woman is not working or she is also working, or the parents of the a man, if they want any maintenance, they will not have the comforts of matrimonial court or the family court, because unlike in any other court, the family courts has a mandatory procedure of conciliation. That we are coming to the next point. So the one more aspect after 7, we'll have to see the exclusion of jurisdiction of other courts. It is not giving an concurrent powers for the family court and other courts. Some people used to say, we have seen in few cases where lawyers will say, no, the matrimonial properties matters can also be filed in the civil court at the same time in family court. We can choose between the either one of these courts, but it is not. It is actually the Family Courts Act excludes the jurisdiction of all other courts. Even now I have a case in hand where some other lawyer from our fraternity, they have handled a matter of legitimacy of a marriage. Whether a marriage has been completed or not is the question, because after engagement, the couple go for a registration without solemnizing a marriage. But with that registration, the couple have applied for visa. And before the civil marriage or without the regular marriage, without the actual marriage between the couple, the marriage has fallen out. So now the families wanted to knock off the engagement and call off the engagement. And they thought that they can revert back to spinster status. But the problem came here because they went and registered a marriage without one being solemnized. So in these cases, whether the marriage that has been registered is valid or not, or what happens to the alleged relationship of husband and wife only on papers, only on law, when they are not actually married, when they have not actually shared their life, or they never started their life, never even started, never consummated. Consummation doesn't even come. So in this case, some of our lawyer friends went to normal civil courts to file a suit saying that this is not a marriage itself, so it doesn't come under Family Courts Act. This is completely wrong. So the validity of marriage and the declaration as to the relationship, here the correct procedure would be, the suit should have been filed to call for the records of the registration department of registering the marriage and saying it should be annulled because the procedure of solemnization itself has not taken place at all. So this is how we have to see. So there is an exclusion of all other jurisdictions when family court has been established. So in that jurisdiction, if the family courts are there and it is present and no other court has jurisdiction to deal these matters, in spite of the parties are willing to go there. So this is a statutorily, this is the only court wherever family courts are established, and it is excluding the other court's jurisdiction. So when it relates to the properties of the spouses, it can be adjudicated after divorce also. Whether now the question comes, the parties, the man and the wife, or petitioner and the respondents are already divorced and they are not husband and wife anymore, but they have properties jointly which has to be settled, or there is a dispute. Now the question is whether the X, Mrs. X and Miss X and Mr. Y can go to family court, or whether it has to be adjudicated in a civil court. So in this manner, in this matter, the Supreme Court comes to our assistance in 2003, 4 SEC 166 in K.A. Abdul Jalil versus T.A. Shahida. K.A. Abdul Jalil versus T.A. Shahida, 2003, 4 SEC 166. In this judgment, Supreme Court has very clearly said that in relation to properties of spouses can be adjudicated after divorce also, because the property has come into possession when they were spouses. So the matter and the problem arose, or the cause of action of purchasing or acquiring or possessing a property happened when they were spouses. So Supreme Court has clarified on this point in this judgment, and we can go through this aspect. So when the another aspect of DNA test has come, till 2000 and 2005 and 6 also, there were not many cases of DNA test that was conducted in civil courts, because the law as a Indian Evidence Act as a prevention, as a presumption, which says the father is a man is shown by marriage. This is a legal maxim. This is a legal concept. That is, if a child is born after marriage, as per law, the husband is the father of the child. If there is any allegation of or challenging the paternity of the child, the man who is denying the paternity should go to the court to prove that he did not have access to his wife at the time when the child was conceived. So the law goes in this manner. When a couple are married and even after 5 months or 6 months a baby is born, the law considers the child is the father, husband is the father of the child, except unless the father goes to the court to challenge the paternity, establishing that he had no access to the mother who gave birth before 9 months or 10 months whatsoever, was not there. Only then the question will be proved otherwise. Otherwise, the law's presumption is man is a father as it is shown by marriage. So in this case, when DNA test is conducted by the family court, in Babani Prasad Jena versus Orissa State Commission for Women in 2010, 8 SEC 633, it is spoken about the DNA test and its relevance and how a person cannot deny when it is challenged or other things. So 2010, 8 SEC 633. This is relating to DNA test and how it is a matter of civil right of a woman to ask for the man to submit himself, and it is not a case against, it is not a right against his privacy. So we should go through this judgment. 2010, 8 SEC 633, Babani Prasad versus Orissa State SCW. Then we can go to the next point. So when it is grant of maintenance, we have to see about it. The grant of maintenance is basically one of the major works that is being done by the family courts. And the Supreme Court has clearly stated, having speedy settlement of disputes is one of the objects of this act. Keeping that also in mind, it has very clearly come down on delay that is happening in the matrimonial proceedings, including maintenance. Especially in maintenance, the Supreme Court very clearly stated the adjournments shall not be given as a matter of routine as in when it is asked for, and it should not be granted. So the delay is not only a delay by the court, it is not a procedural aspect. Supreme Court has stated very clearly, delay is against human rights. The delay is against embodiment of dignity of a person. So when a woman comes to the court and asks for a maintenance for her food, shelter, clothing, medical or educational expenses of the children or for herself, when delaying it is serious inroad and a violation of her human rights and also against her dignity, which is also, we can think of right to life. Under Article 21, right to life is also expanded to say that it is embodiment, that is the dignity of a life is also intertwined with the right to life. Right to life is not just a right like a cattle or a chattel. It is like a human being with dignity. So delay in dealing or deciding the maintenance case or granting continuous adjournments in maintenance case amounts to infringement of the basic right of any person of their human rights, and it is against their dignity. So there are several potential judges who are here in this class also. You should keep this in mind, that whenever there is, the judgment is 2015 6 SCC 353. This is the judgment. Bhuvan Mohan Singh versus Meera. Bhuvan Mohan Singh versus Meera, 2015 6 SCC 353. So this will come into handy for many lawyers who are appearing for women, and we used to continuously fight with the court normally not to grant adjournments in such matters. We all know that right of Muslim women to seek maintenance has been taken off by 1986 Special Act. But after the judgment of Shamima Faruqi in 2015, the right of a woman to file for a petition of the judgment of Bhuvan Mohan Singh is, citation is 2015 6 SCC 353. Yes. And the right of Muslim women to seek for maintenance under 125 CRPC has again been established, has been confirmed and reiterated after 1986 Act in Shamima Faruqi case. It is 2015 5 SCC 705. So the concept of Muslim women cannot approach with a petition for maintenance under 125 CRPC is no more, and it has been the past history. And after 2015 5 SCC 705 Shamima Faruqi case, this has been in practice, and family courts are again and again handling with these matters and entertaining, and also they are ordering maintenance for the Muslim women also. Next we come to some special features and special aspects of family courts, which is about procedure. And before that, Section 9 says the duty of the family court is to see whether it can be amicably settled. So the settlement or the conciliation or whatever they call, for settlement of the matter, it should make some efforts. So the other courts, see, in fact, we lawyers have experience in filing cases in sub-court, which is equivalent of family court in the taluk levels, wherever there is no family courts available or not established. In those places, we also file the same HMOPs, Hindu marriage original petitions, exactly like that in family court. And we use the same provision of Hindu Marriage Act or Divorce Act, or sorry, Divorce Act comes in district courts. So when we are filing these petitions, the efforts for settlements are comparatively much lesser compared to the family court's efforts, because the judges have no enough time. There also, in all matrimonial matters, they definitely post the matter for lok adalats or mediations, where the members of mediation committees and the legal aid centers or the district legal service authority and the retired judicial officers and trained mediators are also sit. But it is not as effective as it is done in family courts, because the family court is mandated to make effective settlements, and efforts for settlement is mandatory even before entertaining any petition. So before the counter is filed, before the pleadings are completed, it is an essential aspect under Section 9. The family courts are mandated to deal with the matters for settlement, towards settlement, as the Act itself is aimed at bringing in conciliation, seeing to that marriages, the families are saved and kept intact. When the procedures are generally that apply of civil procedure code, the family courts has special aspects where all the cases shall be dealt in camera. So the parties who come to the family court need not feel that the sense of shame, or they will lose their dignity if they are going to speak up in the courts. And even in the taluk level courts, even in the principal sub-judges or sub-judges court, now we are able to see the family matters of, or the suits which involve the family matters, though they are not family courts, they are on request dealing with the matters as a in-camera proceedings. So whenever there is no facility, or it is not an in-camera proceedings, definitely on request of the parties, one of the parties, the courts are duty bound to deal with the matters in camera and conduct the proceedings in camera. So even sometimes when we experience certain things, the new judges come take over in family courts. If that is their first experience in the as a family court judge, they tend to conduct the matter in the open to an extent, and then immediately the lawyers fraternity will request them and express their difficulty, because the women clients and the matters are very sensitive, and all these things which is very essentially has to be held in camera and heard in camera and all that. So immediately the judges also accept and approve of it. But now situation is changing. Definitely no requirement for such pleading is also required anymore. So when we think of this special proceedings, the special way of conducting the matter in camera is mandated in the Family Courts Act, and the section provision is given under section 11. So it is unlike the other courts. This is a special court with a special mandated sections, and it saves the women or men their dignity, and also their difficulty of approaching a court for getting justice. So many times before 1984, many women, many families used to say, we are not the one, our family is dignified family, we will not take our matters to the family court or any court. If it is taken to court, then our prestige is lost. So that is all gone are the days. And even many lawyers here, we would have heard our clients saying, madam, you will understand only if there is a matrimonial matter in your family. Sometimes they'll used to say, for men clients also, sir, you do not know what is the difficulty or pain of having a matrimonial dispute, and that dispute coming to court, because you would not know all these things. But now it is so happened that every judicial officer or every lawyer, we have our own experience of our own one of the family members coming to family court, either in the same family or in the extended family. So coming to the family courts is not a taboo, or it is not an indignity. It is not something very to be considered to be shameful at all. I have known several cases where very senior people, IAS, IPS officers, or even very higher level judicial officers also, their families, when the couple are having a problem, they have to approach and they come for the family court. And the ignominy that was attached to the courts when there is a family matter is almost gone. And everybody thinks that family court, going and approaching a family court is not an insult, or it is not something below their dignity, because the family courts are established in such a manner, it preserves the well-being and the sensibilities of the persons, and it is sensitive to the problems because of the procedures which are very special to this court. So it is not an ugly or an insulting thing to go to family court anymore. And the more we are making the law implementable, it is easier for the people to get justice. And the family courts also, we know, they take medical and welfare experts. And so whenever there is people with disability or with special ability, or the matters that cannot be understood by lawyers or the judicial officer only with the legal knowledge, then it is essential for a medical expert like a psychologist or a psychiatrist or a counselor or some specially trained mediator or a child psychologist to dwell upon the matter and give a report to the court. So when the court is getting the report confidentially from an expert, that they will make use of to give justice in that matter. So it is not against one party or the other party. Once the expert's opinion either directly they can assist, like when I'm saying about special experts who are persons who can interpreters or special language trained persons or teachers, when people with some special abilities or partial disabilities come to court, then the courts can understand their pleading itself or their expressions itself through them. Or when they are sent to experts, the experts give opinion or their report after meeting up with the parties as directed by the court. And that report can be applied and received so that the parties can raise their difficulty or their objections if it is against their interest or if it is not based on scientific methods of coming to the conclusion of that report or the contents of the very report also. Though we have a right to challenge all those things, it is a special provision where the courts are compelled to seek the opinions of experts and medical professionals many times, and it is essential. And as a lawyers or family court practitioners, we should also be ready and willing to convince our clients to say that when this is not, when the matter is pertaining to the perspective, a man's behavior will be highly cruel to a wife, but the same act will not be as cruel as for that wife for any other woman or any other person or for the mother of the man. So it is depending upon each and every person. So we have to convince or talk to our client saying that your perspective alone is not the one. Your perspective alone will not be taken as final. There can be 2-3 perspectives, but the experts can throw light upon to see which is on the right or which has to be considered more seriously or which has to be rectified from which point of view. So we need to tell our clients that whatever they say is not gospel truth, even though it is evidentiary value is there. If for an example, in a case, I had a woman, the wife sent messages or yes, emails in a very bad language. The language is per se, when you read it, when the court officer can read it, we'll see that this person, the lady, is not all right at all. And that particular word will cause cruelty for the man. Just the first blush, the court will come to that opinion. But when the matter was gone into, and when both the parties were sent to a counselor or an expert or a psychologist or psychiatrist, then came the report where the courts were able to understand that the husband was denying very basic rights of the woman, and without able to do anything, this person has gone into a kind of depression and a problem. And so was the expression of bad language to vent out her anger. If had she not vent out her anger in such language, she would have gone mad or should have committed suicide or something would have had happened for the child or something. So finally, the lady who had sent very bad language emails got an order in her favor. So these are all the things I would like to say here, because the role of experts, the role of welfare experts or medical experts has a very serious impact over each and every case. And we have to see through a matter from the entire comprehensive manner of the welfare of family and welfare of children and welfare of the person who is affected, who is our client also. So there is not only one perspective, there can be 2-3 perspectives, because in matrimonial matters, we will not have enough evidentiary proof, just like other cases, like in a suit for money or for anything else, like a documentary proof or a voice audio recording or a video recording. So when the lawyers and the public opinion is such that many people used to say, even if you are going to go to court and tell what all you suffered, nobody will accept because you don't have evidence. The husband will torture the woman within the 4 walls, and he will always challenge the women, saying that you don't have any evidence and you will not win the case. So now we are able to see, not only me, all the friends here who are listening to me will not have a second opinion while accepting. The couple are now started living with the evidence creating methods. So when husband is talking, she records. When she is talking, he records. And in phones, auto record mode is app is already loaded. And the husband, without the knowledge of the wife, puts the share location modes. So wherever she goes, he can watch, he can have a watchful eye. So all these things, when it comes to her, then she feels bad that she is being suspected and the problem comes. So everybody wants to live a life by creating records, by creating evidences, by having documents. So this is absolutely a wrong concept. It's an antithesis for the basic trust in the marital relationship itself. So we need to advise our own clients sometimes. Even creating evidence, creating records, creating documents itself is a problem in many cases that we see. So let us move on to the other ones, because we'll have another half an hour time only. So in such matters, or in all matters, the mediation has become very, very essential. And without mediation, many times we will not be able to understand the crux of the point, or the severity of the problem, or the superficial nature of the problem. Sometimes they will talk so much, but the problem will be very simple. It will be very egoistic, or it will be due to some elder members who have some vested interest, and they will be playing along with this couple in a different manner so as to protect their right and all that. So the insecurity of some elderly person may also be the underlying cause, which the couple may not understand, but they'll be fighting. So the mediation and conciliations will throw light on all these things. And mediation is very essential. And in case Srinivas versus DA Deepa, this is the case in Supreme Court of very recent thing, 2013 5 SCC 226. Case Srinivas versus DA Deepa, 2013 5 SCC. You can just put it up here. 2013 5 SCC 226. Srinivas versus DA Deepa. And another matter, Anu Bandari versus Pradeep Bandari, 2018 6 SCC 389. These two judgments are giving right to the family courts to call for or to indulge in mediation or settlement at any point of time. Underline the words, at any point of time. Even at the start of trial, even after commencement of trial also, the courts can make efforts to take, they can take efforts for settlement or mediation. The last citation I said about Anu Bandari is 2018 6 SCC 389. These two judgments we have to go through. Many times we get angry with the judicial officers of family court for having them start again. Once again, they will start for talking for settlement or mediation. But we have to understand they are entitled to. They are given this right by Supreme Court's judgment itself. Srinivas versus DA Deepa very specifically speaks. It can, they can strive for amicable settlement at any stage of the case. Any stage inclusive of trial stage. Yes. So there was another challenge to the family court thing, that is the procedure. Procedure which is adopted is also with relating to the evidence, that is section 14. Section 14 is very special, but it is seldom used. I think it is not being used completely. Application of Indian Evidence Act 1872. This is the section. I am reading it verbatim. It says, a family court may receive an evidence, any report, statement, documents, information, or matter that may, in its opinion, assist to deal with effectually with a dispute, whether or not same would be otherwise relevant or admissible. We all know evidence will be taken only if they are relevant and if they are admissible. The relevancy of a document or a proof, admissibility of a document or a proof. These two aspects are very essential in admissibility or relevancy of any document or any proof, be it oral evidence, be it a documentary evidence. But in the family court, it says, even otherwise, whether or not it is relevant or admissible, as per IEA, Indian Evidence Act, any report, any statement, any documents, any information, or the matter that they can be taken into account, or it can be admitted or taken if in its court's opinion, it assists to deal with the effectually with a dispute. So section 14 was challenged, whether this is violative of article 14, because there are sometimes there are family courts are there and family courts are not there in some places. So this article 14 is hindered because of the special provisions and special procedure. Not only this, the other special procedures also, like mandatory settlement procedure and in-camera procedure and other things. So in Lata versus Union of India, LATA, Lata versus Union of India, 1993, 1 Maharashtra LJ, it is Maharashtra judgment. It said it is not violative of Article 14 of Constitution. So Chapter 4 of Family Courts Act has come under the hammer of courts for deciding on the validity, whether it is violative of Article 14. Then Bombay High Court, the bench had held that it is not. So 1993, 1 Maharashtra LJ 673. As I told you earlier, demand for proceedings in camera, it is section 11 is already stated, and any other matter also we can cite this judgment, and we can get it done in sub courts also. R. Sridhar versus R. Sukanya, 2005, 671 AIC, All India Civil Cases, AIC Madras, 671 Madras. And next we go for the special provision, another special procedure where the video conferencing has come into play, and video conferencing has been allowed, has been accepted to be, can be had, and it can be used in LJ 673, 671, 2000, I think the judgment, 2005, 27 AIC 671. Okay, so the video conferencing is again permitted as a procedural aspect, and it is not violative of any rights for the other party. So it is again in Shantini versus Vijay Venkatesh, 2018, 1 SEC 1. So Shantini case has been widely clarified and thrown light on many aspects of Family Courts Act. We should definitely go through and read this. 2018, 1 SEC 1, the video conferencing. And in Tamil Nadu, in Chennai, the video conferencing rules 2019 has been published in Gazette, as declared by High Court also. High Court has made the rules, video conferencing rules. We should go through. The crux of the point is that either both the parties should be accepting, and there should be a remote person should be there in the remote point to identify the party. So this is one of the provision. So you can go through and Google it to see the Tamil Nadu video conferencing rules that came into force on 19/1/2019. That rules you can just go through and Google it, and you can find it out. So that is as per that rules, it is applicable for all the courts, civil courts and other courts also. Family courts are also bound by that. And if the parties are, one party is here and one party abroad, they can handle the case. And there are some judgments, and courts have decided that it is not possible for both the parties be outside the jurisdiction of the court, and both cannot conduct a case by video conferencing. So if one party is here, the other party is not able to come, with the consent of the another party, that it is possible and it is just and fair, the person who is applying shall be, the court will be giving notice to the other spouse, and the other spouse, if they are consenting for video conferencing procedure to be adopted in a trial or in any other stage of the case, then it will be accepted with the conditions and other procedures that has to be followed. So as we have spoken about application of Indian Evidence Act and record of oral evidence, this is also part of the special procedure. See, in all other courts, the recording of oral evidence is what the witness states in the proof affidavit, or witness comes into the box and speaks about it. But here, it is not required that family courts have to, as per law, it is not required that the family court needs to accept the oral evidence at length. It says very clearly, it shall not necessarily record the evidence at length. In examination of each witness, it shall record or cause to be recorded a memorandum of substance of what the witness deposes, and such memorandum shall form part of the record. See, if the witnesses, if they want to talk about a point or 2 points or about fact or that matrimonial issue, the judge can listen to them even for 10 minutes or 15 minutes, and they can reduce into a kind of a memorandum of the evidence of witness, and they can record it, and that concise portion can be recorded and it can form part of evidence. So this is a special provision that is available in the family court. So this is section 15, record of oral evidence. The family court has got a very special power, and they need not accept to listen to a oral evidence at length. Sometimes we see in family court that is the most difficult cases. That is what many of our lawyers we feel, because the witness themselves will go on and on for a day or two, and cross examinations, even I know it has gone for 7 or 8 hearings, each hearing taking place for 1 hour to 1.5 hours or 2 hours. Even we have that experience. So the family courts are actually entitled to cut short the oral evidence given by any witness, not the cross examination per se, but the witnesses can be cut short and the crux of the point can be taken and recorded by the judge. So evidence of a formal character, it can be given on affidavit. That is also a special provision and right of the court. And what is judgment in the family court? Like any other court, it is also says, just like in CPC procedure, a concise statement of the case and points for determination and the decision thereon and the reasons for such decision. So as in any other judgment, the 4 parts are essential in family courts also. So it says that the family court, even after listening to it completely, even after giving special procedural advantages or special procedures as per the provisions of the act itself, it doesn't mean that judgment can be telegraphic. It cannot be a single line judgment, or it cannot be a non-speaking order. So even after the family courts are given the special procedures as per the law itself, the judgment special, there is one provision of section 17 very clearly says, it has to have a concise statement of the case, points for determination, the decision thereon, and the reasons for such decision. So these are all the aspects that has to be followed in the judgment also. So when it comes to execution of decrees and orders, it is as good as or as normal as any other civil court judgment will be executed. So the execution, many times we think that after passing of decree, the courts have no role on the matter at all. It becomes functus officio. It is not functus officio, because in relation to, with regard to the welfare of child or custody of a child or a visitation right of the child, the court continue to be person who is officiating as having a supervisory power over that matter, and the court can monitor the welfare of the child. This is not given in the act, but Supreme Court has explained this in a very clear manner. We can see in it is a High Court bench, or Madras High Court, in a bench decision, in a division bench it has come, Nitya Vidya Prakash versus Suresh Babu, 2010, 3 CTC 618. 2010, 3 CTC 618. Dr. Nitya Vidya Prakash versus Suresh Babu. In this, the courts very clearly stated that the courts, even after coming into a or giving a judgment or after a final decision also, they can definitely continue to monitor the welfare of the child. So now we can come to the appeal. This appeal section is most very interesting one, because when we see the appeal, there are several doubts and very there are judgments about how the appeal from family courts have to be dealt with also, because section 19 speaks about the appeal. When appeal lie from every judgment or order, there are two aspects. The appeal can be on judgment and order, but the order not being interlocutory in nature. And family court, after the family court, the appeal lies to the High Court. So when this is the first appeal, this appeal can be both on law and facts. So this is the very essential aspect that we need to understand. That is, the appeal can be on every judgment and every order. But in the CPC section 96 says, appeal is against every decree and order. See, there is a difference. In Family Courts Act, it says against every judgment and order. CPC says, section 96, appeal against decrees and orders. So what is the difference, we will see later. And now I would like to say what section 28 of Hindu Marriage Act says. Section 28 of Hindu Marriage Act says appeal from decrees and orders. 28 also speaks just like how CPC is, but the family courts doesn't say appeal from every decree. It says from every judgment and order. So every decree is also a judgment, but not that every judgment is a decree. We will we'll discuss it about the appeal and other aspects little later. So there is a kind of an anomaly which we can understand. We can understand that there is a little bit of, there is an anomaly, because if a woman, she is residing in Chennai, or she is residing in Coimbatore, or any other place where the family courts are established, if she is residing there, she has an appeal to High Court, one appeal. By section 19, 1 to 19, 6 of 19 clause 1, 19 clause 1 to 19 clause 6, it deals about the appeals and revisions in Family Courts Act. But if the same lady happens to reside, having got into a matrimonial home, or if parents are residing in a town where there is no family courts, she has two appeals. One, from the subcourt, it has to, there is the application of Family Courts Act is not there for subcourt, in which the matrimonial matter is being dealt with. So the appeals are as it is provided under CPC. So when the CPC says to an ordinary appeal court, wherever the appeal can be made to, from the decrees and orders, it will go to a district court. From district court, there is an appeal again to go to High Court. So we know when it is a suit, normal suit, it is OS, original suit, and then first appeal is AS, appeal suit, and then second appeal to High Court. When family court, if the same matter or the same kind of couple having problem in a town where their family court is there, it is the decision in family court and directly to the High Court. And High Court also, the bench deals with the appeal. And after that, it has to go to Supreme Court. So depending upon where a woman or a man residing, the appeal is different and it is changing. So person who are governed by Hindu Marriage Act are given an option of having two appeals, but a same person governed by Hindu Marriage Act with the same matrimonial matter, if they are coming to family court, it has one appeal. So when we have spoken about all these things, then what are all the appealable orders, what are all comes under revision? Then that is the question, probably the last question and last aspect of a session also. So when first appeal, we know all, we all know that it is a litigant's right. It is a automatically the first appeal will be admitted. There is no questions asked. So it is a statutory appeal, and litigants' right to be heard on facts and law in first appeal, and it shall not be disposed in limine. That is in the beginning. No AS will be dismissed on the inception or for want of anything else, or if there is no enough ground or anything. So in that manner, the first appeal is like that, and the second appeal, we know, as per section 100 of CPC, it can lie to the High Court from every decree passed in appeal by any court subordinate to High Court if the case involves a substantial question of law. So if it's a first appeal, it can be adjudicated on facts and law. If it's a second appeal, it's only question of law. But I told you earlier, in family courts appeal, though it is to the High Court, though it is a division benches dealing with the appeal, it can be challenged on facts and in law, just like a first appeal. So there is a difference, and in P.T. Lakshman Kumar versus Mrs. Bhavani, which is decided on 23/4/2013. I am not able to take the CTC citation equivalent for this. This is by Justice Nagamuthu's decision, because there was a question whether section 24 of Hindu Marriage Act is appealable or not. And there were several matters that has been filed in Madras High Court as revision and as an appeal against the section 24 of Hindu Marriage Act. So we need to know section 24 is an interlocutory application, and section 25 and 26 also. So I've already taken a class for, and we have discussed in another webinar, section 24, 25, 26, 27 alone. So 25 and 26 at least, they are taken up at the end of the trial or at the time of trial, or subsequent to trial. Section 25 can also be taken because it speaks of alimony. So whether section 24, especially section 24, which is alimony or maintenance pendent light, maintenance till the pending disposal of the case, whether it is an appealable order or it cannot be appealed. If an order cannot be appealed against, only then revision lies. So in family courts appeal, as you see, section 19(4), it says High Court may, of its own motion, otherwise call for and examine the record of any proceeding in which the family court situate within its jurisdiction passed an order under chapter 9 of CRPC. That is, it speaks about section 125 CRPC. So if there is a maintenance order and that maintenance order is passed, and that is a judgment, and in 125 CRPC the judgment is passed, can the judgment be appealed against? No, it says section 19(4) clearly it can be revised, because though it is not an interlocutory order, it is a final order. This one, that is only for the limited purpose of satisfying itself as to the correctness, legality or propriety of the order, not being an interlocutory order, and as to the regularity of such proceedings. So it is very clear there cannot be any appeal or revision against MP in MC, that is interim maintenance and maintenance. So many times we used to file an interim maintenance and maintenance petition itself because it is taking too a long time. The other party needs to let in evidence, and the documents are voluminous, and sometimes both the parties are working. We see lots of matters in family court Chennai, because the parties are, it is not many times fought for food, shelter, clothing. It is for the equal status of both the parties when children are there, and both of them are equally placed on all these things. So when there is a maintenance case going on for 2-3 years, when delay is very inordinate, and when there is no justice, we used to ask for an MP, that is miscellaneous petition, and in the maintenance case itself, to go for an interlocutory order of maintenance order. So as per Appeals and Revisions in Family Courts Act, under section 19(4), no man or no challenge can be made for interlocutory order of a final order of maintenance. So even if it is a maintenance order, it can be revised, it cannot be appealed against. So in this manner, we can see how the Family Court and the Hindu Marriage Act and Section 96 of CPC have three different criteria for appeals. And I'll have to come for the very interesting question of what Section 24, whether it is appealable or it is revisionable order. So Section 24, Allahabad High Court and Madhya Pradesh High Court and Chhattisgarh High Court, all these high courts have decided that Section 24 is a judgment and it attains finality for once. And it is attained finality because, and also it is having impact on the main case. If the woman is not paid the interim maintenance as ordered by Section 24, she will not be having enough capability of conducting the trial in a proper manner as there is no maintenance given for her. So she will be devoid of the right of conducting an effective trial. If the man is ordered for payment, directed for payment of maintenance, and if he does not pay, his defense or his counter can be striked off for disobedience of court, and there will not be an effective trial on his part. So it affects and impacts the final judgment also. So they said this is final by its own. The maintenance has reached the finality under Section 24 and it is payable, and therefore it is appealable order. When it is a order and has all trappings of judgment, and the judgment, if it is after that again and again, they cannot file another 24. So it is not interlocutory in nature. That is final on its own in terms of maintenance till pending disposal. The same cases were dealt in a different manner by Delhi High Court and by Karnataka High Court and by Odisha High Court. So Justice Nagamuthu has dealt all the 6 High Court's judgment in favor of stating Section 24 is appealable, in favor of stating that Section 24 order is not appealable. So it comes only as revision. So he has held that. He said this is an appeal, and he has subscribed to the view of Allahabad bench judgment, saying that within the case of divorce or restitution of conjugal rights or whatsoever, Section 24 reaches a finality within the matter, and that final judgment and the nature of finality impacts the main case also. And so it is an order which can be appealed against. So Section 19(1) says any judgment or order. So judgment is the main case judgment. The order is 24 order. So order is also appealable. In this manner, he says that, yeah, I found this judgment. I am not able to tell you what CTC citation is. Please, you can Google and you can see in Indian Kanun, I was able to get this. Date of judgment is 23/4/2013. So after this judgment, High Court of Madras is considering and on all 24 appeal against all 24 Hindu Marriage Act petitions as CMAs, that is civil miscellaneous appeals. So the CMA is being filed against Section 24 order, and also CMAs are filed against any order in OP. But if the order is about visitation, if the order is about anything else, Section 26 or about Section 27, then it is CRP, that is civil revision petition. So orders which are not appealable can be revised. Revision will lie. Orders against which appeals are pending, appeals can be filed, that are not called as revision. It is not revisionable. So wherever there is no provision for appeal, only then we can revise the orders. So the final orders on anything other than section 24 are revisable. That is, revision will lie. That is section under 125 CRPC, revision will lie. Under section 26 or 27, any interlocutory order within the main case, it is like that. So the citation, the parties' names are P.T. Lakshman Kumar versus Bhavani. Justice Nagamuthu's judgment, though it is very lengthy, it is worth reading to understand this one. And he has also interestingly given an explanation regarding, there are 2 appeals in from subcourts and there is only 1 appeal in family court, that he has stated that the appeal from lower court is having 2 sets because strict adherence to CPC and Indian Evidence Act is followed in lower courts, that is in subcourts and district court. But in family court, the strict adherence to Indian Evidence Act is not there, so that the parties are entitled to move forth and back to make all other documents also available for them. And so there are given 2 appeals, even if they are losing on in one stage. So that is what he has stated. Though it is not very convincing for me, it is also one explanation which people can subscribe to. However, the women who are living in metropolitan areas where more than 10 lakh population is there are having a better opportunity than the women who are, or the men also. So it's vice versa. It's men also. They're having a lesser opportunity. That is what I feel in terms of infrastructure and other things. So, and the final last portion I have come, and finally we can go for questions also. So the miscellaneous provision says act have a overriding effect since it's a special law. Any other act in practice now will not have any say, and this is this will take over, and this law will prevail when there is a difference between 2 laws, whether substantive law and procedural aspect. The Family Courts Act will prevail because this is a special law.